A new chapter in St. Lucia's juvenile justice system was proposed on Tuesday as Prime Minister Hon. Phillip J. Pierre presented the Child Justice Bill to the House of Assembly. The legislation seeks to create a specialized judicial process for children in conflict with the law, prioritizing the protection of their rights and ensuring fair treatment within the legal system. Central to the bill is the establishment of criminal responsibility, with Clause 5 specifically defining the age at which a child can be held accountable. Prime Minister Pierre acknowledged that while St. Lucia has existing laws addressing child offenders, these laws require stronger social services and alignment with the international standards, particularly the UN Convention and the Rights of the Child. The UN Convention serves as a global benchmark, guiding member states in implementing legislative reforms for children accused of violating penal laws.
Keeping the intention of the Act, the enactment of the bill removes the power of the court to impose a restrictive sentence and replaces the power with a discretion to impose a sentence on the child that it considers appropriate.
One of the most notable amendments in the bill revises Section 542 of the current Act, replacing the mandatory 3-year sentence with a provision that grants judges the discretion to impose sentences tailored to the individual circumstances of the child. This change aims to ensure that penalties are not only just, but also conducive to the rehabilitation and reintegration of young offenders.
The bill also amends Section 81(3), correcting the reference to the provisions of the Criminal Code Cap 301, which has been replaced under the Act. Mr. Speaker, basically, it is allowing the court to use its discretion to impose a sentence on a child instead of what happens presently.
However, the proposed reforms were met with mixed reactions. Judicial MP Bradley Felix questioned the need to amend a system he believes is functioning adequately. Felix argued that introducing judicial discretion could exacerbate public perceptions of inconsistent justice.
We have seen in the past where judges or magistrates have that discretion, and for example, when it comes to a gun-related offense, where some offenders may get a slap on the wrist and others may get, the whole 9 yards thrown at them. And as a result of that, Mr. Speaker, I am of the firm belief that, we really should not interfere in what has been working.
He also raised concerns about the age of criminal responsibility, suggesting that teenagers who are often fully aware of their actions should be treated differently from children under the age of 12.
There have been a school of thought that when you look at some of the young people, particularly early teenagers committing various offenses, that these are people who are very aware of what they're doing. Unlike when you look at a youngster, say below the age of 12, for example, and maybe there should be a variation or differentiation as it relates to where the discretion should come in. Should it come in for somebody you consider pretty much a child under 12 perception, or when you look at a teenager, as whether that should be treated differently. So that is.
As the Child Justice Bill progresses, it is expected to continue generating discussion on how best to uphold the rights of children while addressing the complexities of juvenile offenses in St. Lucia. Chloe Dantes, NBC Prime.